everyone who is present today here, to have a good discussion over the art of the judgment reading and how do we analyze. So, give me a thumbs up if everyone is ready and join me on this journey of understanding how is judgment to be read. Thank you so much. Thank you so much, everyone. So, Ankit, will you please help me in
Yes, sir. Please
if
take
my
over.
PPT is visible to you,
Yes, sir. It's visible.
right? So I think it's pinned down and it's there on everyone's screen, I suppose. Is it visible, Ankit?
Yes, sir. It's visible.
Okay. Yeah. So hi everyone. Uh, you know, when we always you know become a part of any law school, the basic thing that everyone goes through is the first semester or the first year per se, which includes some subjects which are very basic, which includes some of you might be third year law student or some of you might be fifth year 5 year law students. So this today this webinar is basically for everyone who is not just first year student but is also the final year student, or even for those who have recently joined the legal profession as an advocate or a legal practitioner. So it basically encompasses the entire journey of litigation, and this journey of litigation and entering into the legal arena involves one of the most complicated, which is, quote unquote, stated as complicated, but it is not so. Uh, what is judgment then? This things which comes to our mind if we are going through any subject of law that is there either in our first year, second year, third year, fourth year, or if in case final year, fifth year. So every subject has some of the other aspects which are related to judgment. Now the thing comes is everyone knows how a judgment is there. It's before us, and we are always told that this is the judgment that we have to refer, this is the judgment that we have to go through, uh, but sometimes we are not told how to read a judgment and analyze the same. So today I'm here to make this easy, or make it more easier for those who might not have this exposure of the art of reading judgments and analyzing the same in certain way, which helps both of us, I mean the people who are listening to me, you guys and me, uh, in analyzing, and I'll help you in every possible way in which I can, in helping you in certain way which not only helps you read the judgment profoundly but also helps you in analyzing it and getting into some detail, intricacies of judgment. So, to move on with this, I'll quote a very good line which was stated by Alexander Hamilton. It was laws are dead letters without courts to expound and define their true meanings and operations. You know, when we talk about law as a subject, there can be various ways of interpretations. Some things which are statutorily written, or maybe which is expressively written in the code of law or the acts or the barracks which we always go through. But sometimes we always bring judgments into this play, because judgments do play a very key role in determining uh, and you know defining laws in certain way, which might not be uh, easily readable, or the which cannot be easily extracted from the statutes which is available. So here the judiciary comes into play. That is very important role. Judiciary does play a very key role in analyzing and writing the judgments in certain way, which helps not only setting the precedents, but also, defining law or making law also, because judgments do follow and they become laws. So I'll give you an example. Sedition was something which was not expressly there in the IPC, but which was there actually in this IPC, but it was then amended, and it was brought into BNS in certain other ways. And Section 377 was also another one determining the rights of LGBTQ and the other communities which are involved in LGBTQ. All these laws, it develops over the period of time. And when we are talking about this, there is something which is always there before us, but sometimes it's not in their statute. So this is how the judiciary will, and it has always been playing a very vital role in defining laws and making laws via judgments, via writing judgments, delivering judgments. I would rather prefer to use that word. So to begin with, I welcome you all again. Now, the first thing which comes to our mind is we have always known what is judgment, but what is the relevance of judgment? So I have the few briefs, or I mean few pointers to specifically help you guys out, where I am, pointing out and what actually the relevance of judgment is. So when we talk about judgments, the thing is, law is ever developing. It's luminous. What does this fluminess means? It means that it is not stagnant. It is not static. It always evolves with time, with society. And as the society progresses, and with with over the period of time, the law marches ahead and it develops. It takes different and various forms, which helps all of us to meet. The judgments will definitely then would march ahead and would help in defining various aspects of which various aspects which determine the time and the societal demands. So in writing judgments and making them very efficient in helping meeting the demands of society and also of time, the role of judiciary becomes very crucial. It becomes the guiding light in helping making the judgments more relevant, because judgments also set the precedents, as I said earlier, and they also play a pervasive role. Because when a judgment is delivered by any high court or a supreme court, because all the high courts and supreme court of the India, when delivers the judgment, they set a precedent, and that precedent is being followed up later on in some or the other way by being referred in another judgments. That is called quoting of the judgments. We always have heard about, if we go through internship and in all these internship times, when we get to see the court proceedings, every now and then when the arguments are being made by the counsels of both the parties, by the petitioner or the respondents, they always refer to some sort of judgments to solidify their arguments in some way, which helps them win the case for their own clients. So that is why judgment becomes relevant, because they have that pervasive role. So moving on to the next slide. Now when we come on to judgments, we seldom, get confused between certain terms which I've mentioned. I think it's visible to everyone, which is judgment and orders and decrees and the judicial decisions and the judicial opinions, the ratio, that is the ratio decidendi and the obiter dicta. Uh, so I'll once again, uh, get myself confirmed that if everyone is visible, I think if everyone is able to see and my slide is visible to everyone, and am I audible? Because I think this is very important part of the presentation because this sets the premise and you know uh, the roots of the entire uh, the session.
Sir,
So can
only
I
the
get some?
first slide of the presentation is visible as of now. So if you can change, so we can like confirm if it's working or not.
Acha, so the second slide is not visible
Okay. Now
now.
it's third. I think it's third one.
Yes, yes, yes.
Yes, sir.
So the slide is misleading terms. Thank you, Ankit, for the confirmation.
Okay.
I think otherwise I would have moved on and people would have missed this. Thank you so much. So yeah.
So you can
So
make it as in full screen. The slides are minimal. You can make it in a full screen.
now is it full screen?
Sir, there is a left top corner. There is a like screen with a pause button. No, yes,
Okay, can you see my cursor going
yes, yes, sir. A little bit left, sir. On the upper section,
left
sir. Right?
on the upper side?
Just yes, yes, yes. That's one. Just just
This
yes, sir.
is
Yes, sir.
acha. So is it visible now? I think no. Acha, leave it. Koi baat nahi. It's okay. Let it be this.
You have to
This place.
you have to scroll that so it will be like changing. To change the slide, like you have to scroll now. Yes, it's working, sir.
I- Is it fine?
Yes, yes, sir.
Is it visible? Like
Yes, sir.
it's at least it should be bare minimum.
Yes, sir. Yes, sir.
Okay. So yeah. Now coming on to these misleading terms which I've mentioned. So we always get confused between all these terms: judgment, order, decree, judicial decision, opinion, ratio decidendi, and the obiter dicta. So I presume the people, I mean, all the people here, some of you might be, the early beginners or the first year students or the second year students. So you might not be, accustomed with all these terms. So do you guys want me to move ahead or you want me to explain all these terms? I think I would rather choose to explain all these terms because all these play a really important role.
Yes, sir. Please explain this term.
Okay, yeah. So, judgment is, basically informally and exchangeably used as a judicial decision, which is, the decision given by the court because it settles down every issue which is, before the court of law. And the court might, give its decision on some or one or every issue that comes before the court while while deciding any matter in fact which is before the court, uh, and then the court while deciding all these issues settling down decide the case by delivering judgments. So this is basically a judgment. So now when we come on when we come to the second term, which is order, CPC, you might not be, some of you might not be able to, differentiate between what is order and what is judgment because some of you might not have read CPC in particular. So when we go through the CPC, that is the Civil Procedure Code 1908, subsection 14 of section 2, it defines what is order. So, it might sound daunting, but it's basically a formal expression which is given by a court. So that is an order. Whereas the decree is something which is also decree is also another formal expression, but the difference here is decree is something which determines the right of the parties. So this is the difference between judgment and order and decree, because, and it is also said, it's not said, but it's there in statute also, that decrees follows the judgment. So when always a judgment is given at the lower court, at the trial court, deciding a civil matter, when a suit was filed and while delivering uh, the judgment, the decree will always be the one which will follow. So decrees is another formal expression which is given by the court of law, and it can be of two types. Basically, it can be preliminary decree and it can be final decree. Preliminary decree can be many decrees. I mean, preliminary decree can be many before settling down the issues and delivering the judgment. Whereas final decree is something which establishes uh, the entire issue, which settles down, which it boils down to every issue by dealing with all these issues in certain way, which helps to determine what are the rights or court किसकी तरफ ज्यादा inclined है. So that will eventually uh, turn into a final decree, and that would be following the judgment. Judicial decision is, I think, as I said, it is exchangeably and interchangeably used in some sort of informal way in the court of law also, when people or the councils do argue that judicial decision is another term which is used for judgments. But there's a difference between judicial opinion and judicial decision. When I was in college, and I was in my first second year days, I always used to think of what actually would differentiate a decision and an opinion when both of them are actually revolving around the same issue. They both are it's almost the same. It sounds same. It always comes to our mind that what actually the difference between judicial decision and a judicial opinion. But when we uh, go into practice of researching and reading judgments and talking to the professors, they will help you out, because this is something which is not defined anywhere. This is only something which can be only interpreted by reading judgments, by analyzing them. And that is why I think I'm here to help you understand what actually is the art of the judgment reading. So, judicial opinion and judicial decision are also very exchangeably used in the court of law, but there's a difference between it, because they cannot two terms with the same meaning. They cannot exist. So, primarily, judicial decision is formally used for the judgments which I said, but judicial opinion is something which can be correlated with obiter dicta. Why am I saying this? For that, we need to understand what actually obiter dicta is. So, obiter dicta is basically, uh, it might be very confusing between ratio decidendi and the obiter dicta, but when we come to what actually obiter dicta means is, it's not actually a part of judgment. Obiter dicta is not actually part of judgment, but it helps to analyze uh, via what the judges were trying to say or trying to point out and ponder upon various legal issues. For example, I would give an example for this, that when we are reading a judgment of this right to privacy judgment. So, for example, when the court of law would be delivering the judgments, there would be several issues regarding Article 19, 21, and 14. And every now and then, when such landmark judgment is delivered, these legal issues which comes before the court of law tries to you know uh, throw some light on all these issues in some or the other way, which helps to establish the delivery of the judgment. That is why it becomes relevant in some way. But ratio descendendi is something which, it points out the principles which are established in the judgment. Because that is something which is used by the court of law while pronouncing the judgment. So ratio descendendi is something which establishes the principle, whereas obiter dicta is something which, is not that relevant like ratio descendendi, but is in the observation, but which are the observations made by the court of law, be it Supreme Court or the High Courts, but it does becomes a part of judgment in some way informally, because these are the observations made in the judgment by the judges while delivering the judgment. So I hope everyone is able to differentiate between these terms, right?
Sir, can you explain the ratio decidendi and obiter dicta once again?
So Saksham, I think I'll give a brief once again, because I think it's something which is, a bit more confusing than it how it appears to be at the end of the session. So do let me know once again. I'll clear this doubt again. So let's move on with this session, because I think we're already running out of time. All right, Saksham?
Okay, sir. Okay, sir.
Yeah. Yeah. So now when we talk about judgment, there are certain things which becomes the element of the judgment. Now, there are basically I have personally categorized this slide into three elements, which is civil, criminal, and the appeal based. So basically, there are certain judgments which are civil matter based, which are civil in civil originated. Some judgments are regarding the criminal matters, and some are appeal based matters, or this appeal based judgments which are delivered by the court. So moving on to the next slide, when we talk about the procedural journey, it always includes how a matter comes before that particular court of law. When we talk about how a judgment is delivered, but we always, while reading judgments, tend to ignore the fact that this judgment might set a precedent. And before setting such a precedent of in the court of law for everyone to refer to all these judgments which are delivered, we always tend to ignore the procedural journey. Because, for example, if we read a nine bench judgment, like, I mean, refer to any Supreme Court judgment. So before nine bench, Supreme Court might have dealt in a five judges bench, which is another constitutional bench. But that five judges bench judgment is then appealed and referred to, not appealed, but referred to a nine judge bench. So these are all the aspects of procedural journey through which a judgment before being delivered goes through. So that is how it becomes important. Now, coming to the description of parties, before getting into what actually a judgment comprises of, we always have to have this thing in our mind where we actually, should remember, but sometimes when the judgments compile so much, we tend to forget the names and description of the parties. Nevertheless, I think when it comes to the landmark judgment, I would say that yes, party names and descriptions do really matter, not just for the court of law, which undertakes all these things under consideration while delivering, because it describes the parties which are actually involved in a dispute, of also taking into considerations how the dispute or the matter into consideration originated in a certain way, which is now before the court of law. So that really helps in remembering judgments, and also why does that judgment do really become important. So description of parties is another aspect aspect of the art of judgment reading. Next, coming to the facts and the contention. Facts and contention is something which is the basic premise of how the the factual matrix which helps in setting the premise for the delivery of the judgment, because that sets the roots of the judgment. And these facts can be of several types. Two of them is quoted here, that is the material facts and the admitted facts. The material facts is something which offers the most relevant and convincing evidences before the court of law. Now, when we go to the trial courts, for every judge or a judicial magistrate which is dealing, or if in case when we talk about the civil judges in the civil matters, when a suit is filed, if two parties are in dispute, and if a land or a parcel of a land is in controversy, so everything that relates to the land becomes the material fact. Because, for example, if a piece of land is in controversy and two parties are claiming the rights over the same, they approach before the court, that is the lower court or the trial court, for determining their rights over the land in controversy. So the party that is, uh, I mean, the party who would be coming and approaching the court would say or claim his or her right over the said piece of land. So every document, which includes, pattas and etc., and various other documents, registries, and even will in case, for that matter, every such document does play a very key role that imbibes in that really helps in quoting the judgments in a much more finer way, because that really helps the judgments to be, if in case the party who is aggrieved by the trial court judgment, when in case wants to appeal before the higher appellate court, for example, if A versus B is a matter which is decided by the lower court, and B, if in case is aggrieved, then B would appeal the same matter before the appellate authority, and the appellate court will then, will be helped in some way by reading those contentions which are made uh, before the court by the parties or their counsels in certain way, which helps the appellate court in deciding the matter, because these material facts which have been taken into consideration by the lower court in the suit will eventually set the premise for the appellate authority or the appellate court or appellate forum in deciding the controversy in a way which is legal, which is judicial, and which is as per the law made. So all these material facts are to be taken into consideration. The other kind of facts is the admitted facts. So ideally, when any matter which is there, as I stated, that any matter which comes from the trial court or the lower court to the appellate authority, all these facts which are being reviewed by the trial courts in their decision does become very, very important for the appellate authority or the forum to appreciate those facts which are taken into consideration or admitted by the trial court while giving the final judgment or the decree, unless I've stated that unless it finds that they are erroneous and absurd. For that is for the appellate authority or the appellate forum to decide whether it is erroneous or absurd. Now, this I think this would be the last slide for the session. So before that, I would have a brief. I would like to help you guys go through the so yeah, I'll just take a minute for all of you guys to understand how all these elements really help in you know determining what all are the key elements and how a judgment is to be read. Give me a second, guys. Ankit, I'll stop presenting for a minute. I'll be back again
Okay, okay, sir. Okay.
by referring to a judgment for that. That would really help all these guys to understand in a much more better way.
Yes, sir.
So, while referring to any judgment, we always, are. Some of you might have also participated in a moot court competition or some other competitions. We always go through all these judgments, citations, and everything. Give me a second. Yes. Sorry for the inconvenience, guys. Is it visible now? I mean, can you see the shared screen? Is it there?
Yes, sir. Yes, sir. It is stopped. It's gone, sir. It's not like visible right now.
Acha, ek minute, ek minute. Yeah. Now, now is it visible?
Yes, sir. Yes, sir. It's visible now.
So, guys, I'm referring to the online database that is the SSC Online, and I hope even if your college does not provide with such database, do let yourself free to subscribe with these databases because that really helps you in referring to judgments with a click away, because these online databases will help you guys to read, not only read but research in a very finer way, understanding the latest judgments which are being uploaded by all these databases which uh, are there on these platforms. So I'm referring to just I was screening to this SEC Online, and if you guys can see this highlighted portion that I'm highlighting, 1976 SEC Online BOM 49. Is it
Yes, sir.
visible?
Yes, sir. It is visible.
Yes. So when we always have a judgment in front of us, the first thing that we have to look for is this content. This content. this content, this highlighted content which I'm highlighting here. Sorry. Is it visible to everyone? The highlighted portion. So I've named this basically the caption of the judgment. So this 1976 SEC online BOM 49 and another citation that is used here by All India Reporter is AIR 1977 BOM 99. Some of you guys would be the first years or the second years who might not be able to read these citations. So I'll help those guys to read these citations quickly. So this is the year that we have to follow when we are referring to the database of SCC Online. Now, when we talk about SCC Online, there are journals of SCC also. That is Supreme Court cases journals. If in case if you had an opportunity to visit a office of an advocate, so a good advocate office would definitely have journals, presented all over the wardrobe, on the walls, big journals, carrying lot of judgments with them. That really helps for the arguments and everything. But this SCC Online is the online database that we are referring to of the Supreme Court cases. That is this SCC Online that I'm referring here. So here SCC Online BOM, that is the Bombay High Court. So now when BOM is used here, that is referred to the citation which is of the Bombay High Court. Now, if in case some of you might have referred to judgments which are delivered by the Rajasthan High Court, if in case. So here the abbreviated form that would be RAJ would be used instead of BOM. So this is the basic understanding of these first three terms. And 49 is the page number here. Now referring to the other citation, which is AIR, that is the citation which is of the All India Reporter Journals. So All India Reporter Journals is another database which publishes their journals, but it is not SCC, but it is All India Reporter. I mean, this is different from SCC, but AIR journals are available in the market. So, for if in case if we have to refer to this Vithal Rao, Uddha Rao, Uttavar and others versus the state of Maharashtra, we will definitely find this judgment in the AIR journal of 1977, Bombay High Court, page number 99. Now, sometimes when we are referring to these citations, take for example this citation, or for example this citation, this citation here is 2005 8 SCC 618. So, guys, I'm here briefing out how to read the citations. Sometimes, it becomes very struggle task also to find cases when, while internship, your advocate would say, chalo beta, bring out that case. I want that case. तो आप journal के पास जाएंगे and you will find those cases, the entire piled up journals before you, arranged in some way, but you might not be able to find that case which is being, asked by the senior counsel. So I am trying to make it more easier for you guys to help you understand. So this 2005 is the year of the journal of the Supreme Court cases. Are you guys able to see this? I think it's not visible to you guys. Now I think it would be visible. Ankit, this SBP and Co. versus Patel
Yes, sir.
Engineering
Yes, sir.
Limited is okay. Yes.
It is visible, sir.
Yes. So now this 2005 is the referred year of the case. of the Supreme Court cases journal. Now, what is this 8? Can someone tell me what is this 8 referred here? Why is this 8 used?
Volume number, sir.
Yes, right, exactly pointed out by Saksham. This 8 is the volume number of the 2005 journals published by the Supreme Court cases. So, this volume number can, go as many volumes as, as Supreme Court cases journal wants. Uh, and the 618, as I stated earlier, is the page number. So I think you guys would be clear with this citation part. Is this clear? I think I've stopped sharing this
Yes,
again.
sir.
Wait a second, please. Yes. Now I think this is we are back again on the case. Another case by the High Court of Bombay. So we have, I think, gone through this citation part. This is the name of the court. And this part, that is before S.G. Mehare and Sailesh B. Brahme, these are the two judges, that is the division bench of the High Court of Bombay, which decided this matter. So this uh, division bench of the Bombay High Court delivered this judgment, which was between the Sri Govind Singh Ji Institute of Engineering and Technology versus KV Enterprises, Hyderabad. So this is the party names, this is the petitioner, and this is the respondent. Okay, so now, before moving ahead, I think, are you guys accustomed with the terms petitioner, appellant, respondent, and defendant? Do give me a thumbs up if you guys want me to proceed with it. And if in case anyone out there is wanting me to help and define this term, okay, I think it's there. So petitioner and respondent and these terms, appellate and the defendant is well there. You are accustomed with these terms. No, no problem. Now coming to this part, this is the case number. Here we refer to the citation. Now, this is the case number, that is the writ petition number 9868 2024, which was before this bench of S.G. Mehare and Shailesh Bri Brahmi, the honorable judges of the division bench, which decided the matter on 9th of December 2024, which was reserved on 22nd of November 2024. It was reserved on the 22nd of November 2024, but it was later delivered on the 9th of December. I think it's well clear by reading these terms, reserved and then decided, right? Give me a thumbs up, guys. I think we are running out of time. I should move faster. Yeah, thank you so much. So now when we move ahead with the contents of the judgment, here is the advocates who are appearing before the division bench that is there. And now, when we know that this division bench comprising of the two judges, the senior most judge, the senior judge, would be the one who would be delivering or writing his judgment, deciding it before the junior judge. That is Honorable Justice Shailesh P. Brahme was the senior most judge in the division bench. So these are the observations which are made. I think I should skim all these things which can be easily read by you. Yeah. So this is very important part. These are the submissions and the arguments which are made by the counsels of the parties before the division bench for the division bench to consider as per the relief and the prayer that they make in their case. So If you can go through these submissions which are made by the senior counsel, Mr. Sachin S. Deshmukh, who pointed out these 7 points in the prayer for the division bench to decide and deliver the judgment uh, in the present controversy which is there. Now, when we go through this second point, here is the case of SBP company and company versus the Patel Engineering Limited, which is cited by the counsel Sachin S. Deshmukh, who are the petitioners, on behalf from the side of the petitioners. While referring to these judgments, these are those judgments which the counsel on the behalf of the petitioner wanted for the division bench to consider while delivering while delivering the judgments. So this is called research when certain law points or issues are to be decided in favor of your party or in favor of the party that you're appearing for in the court of law. So this was the matter which was decided by the Supreme Court in the case of SBP and company. So this was the matter which was here referred by the council. Another submission which was made by the counsel for the respondent was senior counsel Mr. A.V. Anthurkar, who made the counter arguments against the relief or the prayer which was being prayed by the counsel of the petitioner. So these are the judgments, that is the Union of India versus Dhanvanti Devi. These are the counter cases which are there for the court to decide in the controversy. So now, when we talk about the contents of the judgment, I stated that the factual matrix, which is always before the court of law, is made out in the judgments, in the beginning of the judgments, in the initial phase of the judgment. So when we skim through all these pages of this judgment, which is delivered by the division bench of this High Court, Bombay High Court, they had referred to various cases. Deciding over the factual matrix which is there. So now, I think while skimming through this judgment, we'll find the factual matrix as well as the issues which are there before the court of law to decide. So these are the some of the issues which are to be referred by the which was referred by the division bench while adjudicating the matter. So whether the power conferred upon Parliament or the state legislatures, as the case may be, subclause D of clause 2 of Article 223A, or all these jurisdictional aspects, the cases, whether tribunals constituted either under Article 323A or 323B of the Constitution possess the competence of the test of constitutional validity of the statutory provision or the rule. So while referring to all these judgments, we always will find the matter which is for the judge or the division bench to decide in the matter which is posted before the court of law. Now, I want you guys to see how do we go through judgment in a faster and a quick way. When we always are in law school, we always sometimes participate in moot court competitions. Some judgments run down to 350, 400, 500, 1,000 pages, and that really becomes a very tedious task for all of us to do. because reading a 300 pages, 500 pages document, and not just one document, several other case laws. While I was in my college, I was going through judgment, which was around 700 pages document, but it becomes very practically impossible for any law student or even for judges in case when we talk about judges when they want to deliver a judgment. It becomes very it becomes very practically impossible for them to become to skim all to read all these judgments from page 1 to till the end. So what do we do in that thing, in that uh, in that point? So this really helps. I would like to show you guys. Sometimes when we refer to these online databases, they do provide a brief of the entire controversy which is decided. In this case, in a particular case, I would not having something in my hand which can help you guys. Some of you guys would have seen those black highlighted portion where these online databases really help in the judgment reading, because those highlighted and briefed portion. Yes, yes, this. Can you guys see this? The case of Prabhudas Narayan Gedam and others versus the municipal board. Yes. So here is those, those extracts of the judgment, which really helps you figure out while researching, and it also helps, a person like me who's a legal researcher in the High Court, because I cannot go through this judgment entirely. I have to go through various judgments, several judgments, before giving out a brief on a particular matter which is listed before the court of law. So these bold, highlighted portions help in the judgment reading. So the A point is the Constitution of India, Article 2 to 7. Now, when we go to Article 2 to 7, this is the power, I think, if you guys would be knowing. This is the power of the superintendence over the courts of the by the High Court. Article 2 to 6 is the extraordinary power with the High Court. So I will not go in that arena because that will open up many doors for all of us to discuss and decide. But this really helps us to find out the scope of the powers of the High Court under Article 2 to 7 while entertaining challenges to decision of the civil court. Another thing which was decided by this judgment, which was there, was regarding the amendment to Section 115 by the Act 46 of 1999. When we talk about the research, the basic research that everyone does while either fighting or competing in a moot court competition, or while interning, while researching, or while even when some of you might go into litigation in practice, and when you will be appearing before the court of law, wanting to cite some cases, and while referring to all these cases, you'll have to go through all these number of pages of all these pages and documents and various documents that record of the case. So all these things will really help you out in help in in finding and making it more finer. The research would be finer. The time would be consumed much more less as comparative to the judgments which are not having all uh, these scripts or the bold portion or highlighted portion, because that really helps in uh, making more final more finer arguments for your party, or deciding a case in your favor. So moving on to the last slide, uh, I would refer to the slide which was this one. Yes, are you guys able to see this? Yes. So now, the brief of the entire session boils down to this last slide. When any person, like be it me or an intern or a legal researcher or a judge, so these are, you know, the points or the bold points which are very important. First of all, it becomes very important. Uh, it becomes very tedious, or it becomes very tough for anyone to frame all these points. But when all these things are before us, the background of the case, the outline which involves the issue and the relevant laws which are referred, all these things, all these points which actually consist of the entire framework of the judgment, all these things eventually will help anyone, be it a judge or a legal researcher like me, to refer to that judgment in a more crispier manner and in a faster way, to understand the controversy behind the case or the judgment which is there in this case comment framework. So, referring to uh, this slide, when we talk about the background, uh, I think this is the procedural journey which I have stated earlier. Outline is something when we go to the judgment, when we go through the judgment, the issues are which are involved and the relevant case laws which are involved in the case or the judgment which is delivered by the court of law. These things will help you eventually find out and figure out what is the actual controversy which was decided by the court of law. Then we talk about the stand of the prosecution and defense, that is, the counsel appearing on the behalf of the petitioner and the defendant or the respondent. That will help you out to make your arguments or make your research much more finer. And this will eventually help you understand how arguments are being made, how prayers and reliefs are being sought by the parties or the counsels appearing on behalf of the parties, which will eventually help them figure out or I mean to get the judgment or the decision in their favor. In all these things, the arguments made by the councils are does really become very important. Second is the scrutiny of the case by the appellate court. Now, for example, if a case has already been decided at the trial court or the lower court in a suit, in a civil matter, and now when the aggrieved party comes before the appellate court challenging the judgment or the decree, if it's a civil coup, if it's a civil suit, if it's a civil matter, then the appellate court will have to boil down to the boil down to the observations which are made by the trial court. That would be really that would be really helpful for the appellate court, and certainly would become very beneficial for the researcher, be it an intern or a judge who is referring to it, to that judgment, because that will help you to scrutinize to scrutiny to scrutinize the cases or the factual matrix or the issues which are involved in the judgment. Another point is the examinations of the precedents which are applied. Now, for example, suppose a judgment in the near future or any time when it is delivered by the or which would be before the court of law to decide on the matter of right to privacy, for example. Now, for that for that thing, the right to privacy judgment would be referred by by that court which is deciding the matter. So that becomes really relevant, because how do the courts examine the issue of the privacy will eventually help the court of law in framing the judgment in a much more better way. So this is something which really helps the court of law in exercising its right, in exercising its duties of delivering the judgments in a much more feasible manner, in a much more judicious manner, because as and when any case comes before the court of law, the appreciation of the precedents or the examination of the precedents do really becomes very important for the court of law to appreciate all these things which are already made uh, by the by the court, be it high court or a supreme court. Another is the examination of the evidences. Now, when any criminal matter comes before the court, and there are certain evidences which are before the court, and some evidences are made up, and some evidences are ad- you know are to be admitted. So the value, evidentiary value, which is associated with every with every evidence which is presented before the court of law for to decide, the examination is being made, which is well, which is there to be appreciated by the court. So it becomes important of the matter of how that judgment, of how that evidence is being evaluated, because it becomes very important not only for from the party's perspective, but it also is very important and crucial for the from the judge's perspective, from a judgment perspective, because when in case in a criminal matter, the life of the accused is at stake. For example, the charges of 302 is framed, or now 134 and 133, if I'm not wrong, which is there in the Bharatiya Nyaya Samhita. So the charges of 302 are framed, and the evidences are presented before the court to decide, and the court will appreciate those evidences. All these all these procedural aspects which are related to the examination of the evidences are really important. And when we refer to all these things, these evidences which are there, we find the glimpses of these appreciation or the examination of the evidences in the judgments. So coming on to the next point, that is arguments and reasoning, it is well there. Obiter dicta is, as I stated, is something which is the observation, informal observations, or maybe in some cases, the points which are severally, which are several times referred by the court while delivering a judgment. Ratio decidendi is something which is, as I said, is the ratio which is made out by the bench or the judge in particular who is deciding the controversy. Uh, Now, moving on to the last part, which is the contribution. Every case which is decided, some, which holds some value, uh, be it reportable or non-reportable judgment, holds some legal value, and it becomes, if it is good law, if a judgment is passed considering all the legal aspects, the examination of the evidences, the trial, if it is a judicious trial, and if it is a fair trial, all these things really contribute to a good law, and it turns out to be a good law. And every good law then becomes a precedent for every other judgment which follows after that. So even if some of you might be the judiciary aspirants, so if in case tomorrow when you become a judge, all and you face two parties arguing on the behalf of their parties. So two counsels appearing on behalf of their own parties, and when such evidences, or if in case if it is a civil case, every evidence every document which is which is presented before you, if in case, then you have to appreciate in a legal manner, in a right manner, in a fair manner, and in a reasonable manner, because all these things contribute to eventually, all these things contribute eventually making that judgment a good law. And all these good laws somewhere becomes, reportable if these judgments are passed by the High Court or Supreme Court. So this is how I think the entire session is I think is now is boiled down to something which we can extract of how a judgment is to be read and how do we really analyze it. Because reading a judgment might be an easier task, but analyzing that judgment do become very important for any law student at any point of time when either they are interning, when either they are practicing in the court of law, or even when, if in case some become good judges. So with this, I would really appreciate for your, keen listening and lending your ears to me, because I think this is all I can have on the table for you guys.
Sir,
Thank you so much.
it was really amazing sessions. We can expect from anyone, and we cannot thank you enough for this session, sir. Like every segment or element you have broken down, like every exam through, like explaining everything through the examples. It was really amazing, sir. I hope everyone feels the same. But would really like to thank you so much for these sessions, and would love to like get together one another sessions as well. And I really loved this session as well, sir. And I cannot really express the thankful in my words, sir. It was really amazing for, I hope, everyone. So
Thank you so much. Thank you so much, Ankit, and the entire Legal Sync team, for giving this opportunity. I think I was really busy today with some urgent work, so I could not help you guys with the session at 7 p.m. But it certainly started off on a good note, and I think it ends with a good note also.
a very good note, sir. A very good note, sir. It was really amazing, sir. Okay, so I think there are some students who want to ask something. Saksham, are you
Acha,
there?
yeah, Saksham is there to ask something.
Yes, sir. Sir, I have a query. As you mentioned, whenever we are going through any judgment, which is often 500, 700 pages, right? So,
Yes.
what are the approaches which we have to follow? Are there any uh, thing to analyze facts of the case or the arguments put by the petitioner or the respondent side or any other thing. So, what are the approaches, sir? So, to understand the crux of the case, because sir, this I have noticed this problem, and when I was preparing for my one of my moot court competition, I'm in second year student of Bhakti Vidyapit, Pune. So,
Okay.
sir, yeah,
Yeah.
I faced this problem, sir, when I was preparing for that moot court competition. I was it was very hectic to go through all those pages and to get through all about the case. So can you explain about this thing?
I got your point. I got your question also. Saksham, when we talk about any judgment which is there before us, first of all, the really crucial point before reading a judgment is actually finding out the right judgment to read. That is really important. Because unless something which is not on the table, you cannot have it. You getting me? If it's there on the table, then only you'll be able to have it. So
Yes,
if
sir.
you have a good judgment, then only you will be able to make a good read, and you'll be able to understand the crux of the case the way you want. Sometimes when if in case taking an example of your own case where you were trying to participate and compete in a moot court competition, there are certain times when we you know uh, not certain times but always. when we both have to when we have to participate or argue on both the behalves. I mean, you have to appear for the petitioner also, and we have to appear from the respondent side also, because the
Yes,
moot
yes.
court competition comprises of representing the team on both the side. So, eventually, when you have the judgment after researching, and when you have the judgments on the issue that is relevant, what is important for you to take note of is, first of all, try to read the factual matrix which is there. And now,
Okay.
if in case when you want something which is similar to the case in which you are dealing, and if the factual matrix resembles to the same which is there in the judgment, this will eventually help you to set your research in a much more better way than weirdly and trying to find out something from the scratch. So it's better to delve into the intricacies of research first, find a good judgment which have something on a very similar footing. If we talk about the facts, if in case they are similar to the mood proposition or the factual matrix, if in case you are arguing on behalf of the parties. So if the facts are same, I think you would be really lucky to be one of those counsel who would have that judgment in hand, because it's really tough to have something in our hand which is eventually help which will eventually help you uh, argue your case on the similar footings. But now, if in case the facts are not the same, try to move on to the issues which are dealt. Issues are something which will which will really help you to compare two different cases. For example, if you have a moot court proposition which talks about you know any for example right to privacy. So if you have this thing, uh, the scope of the fundamental right, article 19, the freedom of speech, expression, and even in case the article 21, all these things which becomes a part of your issue or the moot court proposition. Now when you extract all these issues, now this is not for this is not just for moot proposition, this is for the entire litigation and the advocacy, the practice before the court of law. When you have something before you, when a party appears before you seeking some relief, wanting you to appear on their behalf, to fight a case, to give them to fight for their rights and eventually decide the case in their favor, they will eventually give you a factual matrix कि साहब ये cases है, मतलब ये facts है, and all these facts are to be considered by you, and then you'll have to figure out what are the issues which are involved in it. Because issues एक बार फ्रेम हो गए, when you extract all these issues, किसी चीज का निचोड़ निकालना is finding out the issues which are involved in it. And once and for all, if you find out that what are the issues involved in it, you will you will swiftly move on to that judgment while researching, which deals with the same issue. For that, you have to have a good research skill. That is another aspect. But now, when we are talking about the approach towards how a judgment is to be read, this is really important, uh, because finding out the right legal issues, the correct legal issues which resembles to the proposition or the case or the facts which you are dealing with, it becomes really important to find uh, that issue in the case which you are referring, because that will help you to decide whether this case is on your side or on the other side. आप समझ रहे हैं? For example, uh, if a case has been decided on an issue A and the similar issue has been dealt in some other case, then you have two similar cases. But now, if that case which you are referring is decided against you, so this might be a possibility that the council or the party who is against you might turn up with that case. So that helps you to frame arguments in such a way that you will counter those things which are there in that judgment, which might be referred by the other party which is against you. जजमेंट अपने फेवर में मिलना तो ठीक है, it can be referred by you, but something which turns out to be against you, this judgment which is against you will help you to make your arguments in a much better way, because this will help you to make and counter those arguments which are dealt by that judgment in that judgment. So this is the facts and the issue. These are the two main things. So third and the most important thing, I think, would be the the, the principle that is being set, that is the ratio of the judgment. If the principle and the conclusion of the judgment is in your favor, then I think that would be easily, that would be easily approachable by the council जिसके behalf पे वो judgment उसको favor है. Am I audible? Am I
Yes.
clear?
Yes,
Yes.
sir.
So I think these are some of the points, when we are reading a judgment, when we are going through a judgment, it becomes really important. Now, I'll go through that slide again, where I was referring to this. The last part of my slide, the case comment framework. I think these points will, I think, really help everyone out here. Yes, this one. Is it visible to everyone? Take note of all these points. I'll share this PDF, this PPT with the team Legal Sync, and I think if in case they can forward it to you guys, this will really help you to understand, or you may take a screenshot of this case comment framework, because this will eventually help you to understand the case or the judgment which you are reading or going through. Another thing is, I was always, of this opinion when I was in college, that I should do, some brief compilation of all these judgments. Although, it was too lethargic to do, to be very honest, because it becomes very tedious task to read those judgments which you are reading and then noting all those judgments. But I have some of those judgments with me. Uh, Not readily available, I think I should have, but it's fine. With these pointers in your hand, it will really help you to figure out what in case if a judgment comes before you and you make note of those landmark judgment in such a way that can be referred after after some time, or if in case you're dealing with some controversy or an issue and it comes before you that yes, this is the case which I've referred to earlier in my days when I was noting and I was reading this judgment I was going through. So these some pointers will really help you to figure out that controversy and help you out in the research work or anything. These few 12 or 13 pointers, if I'm not wrong. I think I'm not
Well,
numbered them.
your sir, screen is not visible, I think.
We will
Whichever you
share
said.
the PPT as well in the group. Okay, so
Yeah,
don't worry.
that's a good idea, Ankit. I'll do give this to you, and uh, he'll definitely share it with you guys. Yeah.
Okay, sir. Sir, I have another query, sir. Like,
Yes.
whenever we are reading or like finding out the facts or the arguments of the councils, how,
Hmm.
like, is it any tips to reach to the facts or the judgments? Or like, कैसे मतलब वहां पर फैक्ट्स किधर होंगे उस पूरे जजमेंट में, या आर्ग्यूमेंट्स किधर होंगे,
Yeah.
वहां
So
कैसे
this
जज
is
पहुंच सकता है?
something I was listening to Justice A.K. Sikri once, and he said in his lecture, or I think it was his lecture or some kind of podcast, where he was being questioned, how does this, how do we find out which case is important and which case is less important, which case is more important. I would say, Saksham, to not only to you but to everyone who's listening to me, that this is actually something which comes with experience. When you would have gone through 50 odd cases, not just referring to a book which gives some extracts, but actually reading those judgments. I had people in my college days who were preparing, who were moving in my team also, who were only assigned with the task of research, and we had to go through around 500 thousands of cases. I think 500 was bare minimum for competing in a moot court competition, a good standard moot court competition. 500 cases. And I think, I would not say that this is a very easy task. This comes with time, this comes with experience. And, even the Honorable Justice A.K. Sikri, he truly said, very, that was an honest reply to the question which was asked to him, that this is something when you are grilled in those pages and then in those documents which you go through, you try to find out the facts in the initial stages of judgment reading. But when you are accustomed, and when you get experience, and when you you know have those cases in hand, and after hundreds of judgments being read by you, and if in case someone comes to you and then uh, asks you to, कि sir please बताइए, uh, what is the gist of this case? And in half an hour, I would say, if it is good judgment, is a good if the judgment runs down a good number of pages, I think half an hour would be more than sufficient for you to find out what actually the crux of the matter is. Another one more point, another point I think I missed it while I was presenting is the ratio of the judgment. Not ratio decidendi, but ratio of the judgment. For example, I am not sure, but K.S. Puttaswamy with the right to privacy judgment, which I'm referring in this session, I think it was 4:3, if I'm not wrong. If it is, if it was a seven judgment, I think I should. You can cross check it. I might be wrong, but I think it was 4:3. So that really helps you to figure out which judge is in the favor and which is the judge who is descending, who is giving a descending opinion. It's not always important to refer to the part of the judgment which is being delivered in favor of the principle settled. No, I would say you should also give a brief read or a read to those dissenting opinions of those judges which are there in that judgment. Honorable Justice Indu Malhotra has, in many judges, has given dissenting opinions. You should read those dissenting opinions. These are the landmark judgments, and even the Sabrimala case, which was decided by the Supreme Court. The female judge, I think it was Indu Malhotra, ma'am, Honorable Justice Indu Malhotra, who gave the dissenting opinion. So those excerpts of those dissenting opinions really help you out in understanding what actually the matrix is, the matrix of the judgment. So this will eventually help you to develop that legal acumen. And this, as I said earlier, this comes with experience. While going through hundreds of documents and hundreds of judgments, and when you read all these things, and when you get into this practice of judgment reading, you become the artist That is why I said the session should be named as the art of judgment reading. So I think that answers to your question, Sakshan.
Yeah, thank you so much, sir.
Thank you, Angesh.
Okay, Sakshan.
Thank you so much, sir, again. And I hope no one is there to ask any more questions. So once again, I would like to really thank you, sir, on the behalf of the legal team and legal sync team, as well as the participants. It was really a grateful session for all of us. So I
Indeed,
cannot really
indeed,
express the
Ankit.
how grateful I am through my words, sir.
Yes. I think I I could do justice on my part to help those guys. I think I suppose that everyone who is present here and who was present, I think some of them has left the meeting also. But I think when we talk about the analysis of the judgment and the various aspects regarding how a judgment is to be read, I could do justice to not only try to help out anyone who is there in need of it, because some of you might be belonging to those colleges or universities where you might not be having such online databases and people to
Yes,
help you out with what actually uh, and how what is actually the art of judgment reading. So I think I did justice to those people who helped me out in my college days, who helped me out in presenting today, and who I am before you, talking about what is the art of judgment reading and how do we analyze those things. I think this is something which I can really help you guys. I mean, thank you also for helping me out with such an opportunity to present on this interesting topic today. So thank you so much, Ankit, and the entire team of Legal Sync.
thank you, sir. Thank you. Okay, so
Thank you so much, Ankit.
okay. So before moving, before ending the session, I would like to I'm sending a feedback form in the chat box of the meeting as well, and please fill out. Once you fill out the form, we will circulate the participation certificate on your email. You can check out there. So I would just give me a second. I am sending the form. Okay. So I have sent it the feedback form for all of you. Please fill it out. As soon as you fill this out the form, we will circulate the certificate on your email. Okay, and I would really appreciate all of you to give your honest opinion. If you are want to add anything in the future webinar or the session, we would like to improvise if we have done anything wrong or something. So once again, thank you so much, sir, and that's all I can say in my words. I have no such words that can really express my gratefulness for you. It was really a great opportunity for me as well as the other participants who have got no opportunity like other resources to go through. And it was really amazing sessions for all of us, sir.
Thank you once again.
Thank you, sir. Okay, everyone. So please fill out the form. As soon as you fill out the form, I will circulate your certificate on your email. Okay, while you are filling out the form, I would
How
like
to
to
ask?
ask,
Are
are
you